How did torture come to be legitimized and then delegitimized in the 21st century? Why did lawyers play such a prominent role in the fight against torture in the United States? Welcome to Connections, the Arab Studies Institute interview program on current events, policy questions, and new ideas. I'm Mouin Rabbani, and for this episode of Connections, we're delighted to be speaking with Lisa Hajjar. Lisa Hajjar is Professor of Sociology at the University of California, Santa Barbara, whose work focuses on the relationship between law and conflict. She's the author of Courting Conflict and also of Torture, A Sociology of Violence and Human Rights. Her latest book, The War in Court, Inside the Long Fight Against Torture, was published in October of this year by University of California Press. She is a founding co-editor of Jadaliyya, which produces this podcast, and a member of the editorial committee of Middle East Report. Lisa Hajjar, it's a real pleasure to welcome you to Connections.
Thank you, Mouin. It's nice to be here.
I'd like to start by reading an excerpt from the introduction to your book, The War in Court, and I quote, "Because the prohibition on torture is absolute, everyone, everywhere, and under all circumstances has the right not to be tortured. This makes the right not to be tortured the most universal right that human beings have, paralleled only by the right not to be enslaved, because there are no exceptions to these prohibitions. The right to life doesn't compare because there are many ways in which people legally can be killed and circumstances when killing is not a crime," end quote. Your observation notwithstanding, Lisa, the United States in the 21st century legalized torture. Explain how this came about.
Well, the legalization of torture, first of all, just because a government legalizes torture doesn't actually make it legal. It just makes
legal
it
but not lawful.
Right. Well, it just means that the government has manipulated its interpretations of the law, but the rest of us can look at it and say that doesn't fly. So, the US government obviously has a much longer history of engaging in torture, but what really distinguishes the 21st century of developments was that it was the first time in the nation's history that the government authorized a policy of torture and then varnished it with these legal opinions, basically narrowing the US understandings of the law in order to justify a whole range of violent physical and psychological tactics. This was obviously related to, or a response to, the terrorist attacks of September 11th, 2001. But the idea that the government needed to torture the shadowy enemies that had perpetrated 9/11, and that torture, and the presumption that torture would work, or that it was the only thing that would work, was based on a set of false propositions that top officials, including former Vice President or then Vice President Dick Cheney, held. They believed basically that these enemies who perpetrated 9/11, whom they didn't know who they were, at the time they started thinking about this, would only be broken, and we could only get actionable intelligence from them if they were subjected to coercive interrogation, which then also required incommunicado detention and disappearing people.
Mm-hmm. And what were were there specific legal opinions or legislation passed to make this program and waterboarding and all the rest of it possible? Or was it more a set of operational directives? How did that work exactly?
Right. Well, at the very beginning, in the immediate aftermath of the attacks, Vice President Dick Cheney took control of the national security portfolio, and he and his legal counsel, David Addington, and a small group of government lawyers from the Justice Department, the Pentagon, and the White House, who called themselves the War Council. They basically started strategizing about how to what kind of policies the president should institute, and started sort of thinking about how to reinterpret U.S. legal obligations in order to make it possible to, to authorize interrogators, both military and CIA, because the CIA was also authorized immediately after 9/11 to embark on its own killer capture mission.
And if I could just interrupt you, I think a key point here was also that the US determined that the Fourth Geneva Conventions, or none of the Geneva Conventions, would apply to any individuals captured by US forces in Afghanistan and Iraq and elsewhere.
Right. Well, if you want a forensic account of how this unfolded, and it's a very good question. It was actually the Third Geneva Convention, but so these lawyers, particularly, this group of lawyers who called themselves the War Council, led by Addington, in October of November 2001, they started figuring out how to kind of construct a legal paradigm, and they called it the so-called new paradigm, to basically, presume that the president's power is unfettered by law, and that our enemies in this newly declared war on terror would be absolutely rightless. And so one crucial stepping stone to the torture policy is President George W. Bush's executive order that he issued on November 13th, 2001. This was the order in which he basically said, anybody whom I determine is involved in international terrorism will have no rights to challenge their detention or any aspect of their treatment in any court anywhere. And those whom the government would choose to prosecute would be prosecuted in these new military commissions that would not be subject to normal rule of law, including that they could be prosecuted on the basis of coercive, coerced statements. Now, November 13th was an important day because that happened the day that Bush issued this order. And by the way, the order was devised outside of the normal channels, so the State Department was not involved, in this, or any of the kind of normal channels of people thinking about what to do with detainees. But what was so important about November 13th, and probably the reason Bush issued this order, which was written by Addington, was because that was the day the Northern Alliance, which had, prior to Afghanistan, in Afghanistan, had been warring with the Taliban. But then when the Operation Protecting Freedom or Advancing Freedom, whatever, I'm sorry, I forgot the name of the invasion, the name of the operation to invade Afghanistan in October. But so the Northern Alliance was allied.
Enduring Freedom, I think.
Enduring Freedom, that's right. Sorry. And so they were allied now with the US and coalition forces, and November 13th was the day the Northern Alliance took control of Kabul. And so that was the day when really capture and detention operations begin escalating. So then, you start rounding up people in Afghanistan, and, interrogators were being told. At that time, there wasn't really a clear policy, but military interrogators in Afghanistan were basically told, take the gloves off, we need intelligence. And so the interrogators didn't even know who they were getting, who was coming to them, or what the criteria were, et cetera. But in December of 2001, then with this War Council's advice, Guantanamo was selected as the site for long-term interrogation and detention. And so all of these acts are sort of like building blocks to what comes. There was an internal fight within the administration, specifically Secretary of State Colin Powell and the State Department's legal counsel, William Taft IV, were pushing back against the argument that the president could just declare the Geneva Conventions inapplicable to the war on terror. And so this fight goes on in like December and January. And then on February 7th, 2002, President Bush sides with the War Council and declares that members of Al-Qaeda, Taliban, and anybody else who ends up in US custody on the suspicion of being a terrorist, or now named an unlawful enemy combatant, would have no rights to protections under the Third Geneva Convention.
Which relates to prisoners of war.
Right, it relates to people who are, it's what they call the Third Geneva Convention is the humanitarian baseline, because it basically provides Geneva Convention protections to those people who maybe don't qualify as soldiers of another country. But it basically is to say, if you're capturing people in war, regardless of their status, they cannot be tortured or subjected to cruel treatment or outrages of human dignity. And Bush basically sided with the War Council and said, yeah, that doesn't apply.
Right. So then continuing on this, in your book, you recount how the US torture campaign, which you've just described, was intended to be conducted in secret and how the secrecy was successfully achieved for the first several years. Yet the details, which you also describe in great detail, eventually began to emerge. How did these details come to light?
Right. Well, the real thrust of my book, The War in Court, is looking at and it was mostly lawyers and their human
Right.
rights allies, et cetera, who pushed back. And so the origin story of the fight against torture really begins with the late Michael Ratner, who was the executive director of the Center for Constitutional Rights. And Ratner was very shaken up by President Bush's November 13th military order. Like, what? The president is asserting the right to secretly detain people. But then when Guantanamo was selected and the first detainees were airlifted from Afghanistan to Guantanamo on January 11th, 2002, Ratner, teaming up with a couple of death penalty lawyers, Joe Margulies and Clive Stafford Smith, and a human rights lawyer, Stephen Watt. They had gotten the names of a couple of people detained at Guantanamo, David Hicks and 3 British citizens, and they basically decided to challenge the president's authority to secretly detain people at Guantanamo. So on February 19th, and they didn't even know what was going on at Guantanamo. They just knew that these people were being secretly detained on the president's order. So they filed a case called Rasool v. Bush on February 19th, 2002, very soon after the 9/11 attacks. And that case, what I would refer to sort of as like the opening shot in what eventually develops into a war on terror. The lower court dismissed the case, said, "Oh no, this is not really the court's jurisdiction." The circuit court, when it was appealed, also dismissed the case. And so during that period, secret detention continued at Guantanamo. The names of who was detained there, their ages, their nationalities, all of that was classified information. But
And there were, sorry to interrupt, but at this stage, there were suspicions, but no hard evidence or confirmation that torture was being conducted.
right. The first real break in the fact that the US was using so-called stress and duress tactics, which is a euphemisation for torture, was a groundbreaking article by investigative journalists Dana Priest and Barton Gellman in the Washington Post on December 26, 2002. And that was the first inkling that there was actually, torture was being utilized, although the officials who spoke off the record said, "We were sure the American people will endorse our use of violence and, in order to save ourselves from the scourge of terrorism." But it was really only, so all of the secrecy, part of the secrecy of Guantanamo was because Guantanamo was created as an interrogation laboratory. And so, they were, from November of 2002, Secretary of Defense Donald Rumsfeld was authorizing military interrogators to use the same kind of torture tactics that had secretly been authorized by the CIA, which started running its torture program in March of 2002. But, it was when so all of this was going on, and secrecy was crucial, right? I mean, the government had this contradictory position. It had persuaded itself that the only way to get absolutely crucial intelligence would be to coercively detain people. There was also the hubristic assumption that everybody at Guantanamo was a terrorist because, and it was bolstered by President Bush's order that nobody had a right to challenge their detention. So if you were in custody, you were a terrorist. If you were a terrorist, you needed to be subjected to coercive interrogation. And therefore, that was part of the reason why they had to be held incommunicado. But the real breaking point comes when the Supreme Court in June of 2004, a majority of the Supreme Court basically finds in favor of Michael Ratner and CCR and says, you know what, detainees at Guantanamo do have habeas rights to challenge their detention in federal court. And that was, sort of a big game changer.
So as the title of your book, The War in Court, indicates, lawyers, as you've just been describing, were central to the fight against the US torture program. One of the more interesting aspects is that this group included not only those we would expect to be in the forefront of this battle, like Michael Ratner and the Center for Constitutional Rights, who you just mentioned, but also counted among its ranks government and military appointed lawyers like the Military Commission's Defense Office. What role did they play, and how would you explain their prominence in this story?
Okay, so I want to come back to the sort of the broad range of lawyers who sign on to represent Guantanamo detainees habeas counsel. But the story of military lawyers is a really interesting one, and I, sort of track it in my book. When in 2003, when the Bush administration, well, everything's still secret at Guantanamo, the Bush administration starts lining up a couple of people to prosecute in these new military commissions that are permitted by the president's order to use core statements. And so they start picking a few military lawyers, JAGs, Judge Advocate Generals, who are selected to defend the first couple of detainees who are selected for prosecution. And these detainees that they had selected were hardly, like, by any stretch of the imagination, as we now know, like big terrorists. I mean, one of them was Osama bin Laden's driver, Salim Hamdan. And then, there were a few other minor folks. But so the military lawyer who was assigned to represent Salim Hamdan was Lieutenant Commander Charles Schmidt. And he basically, once he met his first of all, he was given orders because, the Pentagon thought, we're going to get a couple of quick convictions and we're going to, persuade an increasingly skeptical world that Guantanamo actually and the military commissions are effective and these are terrorists and we're going to get convictions. And so these military lawyers were basically ordered to plead their clients guilty.
So to work with the prosecution effectively.
To basically just, tell their clients, like, plead. In other words, like, that the military defense lawyers were assumed, like, were going to be used as puppets to achieve a political end. But what happened was, Charlie Schmidt and a handful of other military defense lawyers basically said no. They said, we're lawyers and this is completely contrary to the rule of law, and we're soldiers, and soldiers' duty is not to advance a political agenda of any administration, but to defend the Constitution. And so they started pushing back, and Charlie Schmidt ended up actually suing Donald Rumsfeld in the Supreme Court in another critical case called Hamdan v. Rumsfeld.
And sorry to interrupt, but you interviewed Schmidt extensively for your book, I believe.
Yes, he's a real character. And really played a really interesting role in this. And part of the role, he and the other defense lawyers, and not just the first batch of military defense lawyers, over the years, and until now, the military commissions are still malfunctioning, but military lawyers who were assigned to defend people overwhelmingly, stood up for the rule of law and contradicted what the Bush administration had originally assumed, was that if you're a soldier, you're going to be right wing. If you're right wing, you're going to hate Muslims. You hate Muslims, you're going to go along with the program. And basically, that did not happen. And so something unprecedented happened in this context. It was like where there developed a military-civilian alliance among lawyers. And so part of the fight against torture involves all these, various civilian lawyers of all stripes and dispositions, as well as a bunch of military lawyers. So it really was a very fascinating and unprecedented, alliance of people who all were opposed to the abusive treatment of prisoners and the vast gap between what was happening at Guantanamo and elsewhere and the rule of law.
And would you say that an important part of the added value of these military lawyers was that they had greater access to the system because they operated within it?
Yes, that was definitely the case in the beginning. Their first military defense lawyers went to New York in 2003. They met with the lawyers from the Center for Constitutional Rights and others. That's where it comes. Much of the information they had, however, was classified, but that didn't bar them from sort of fighting. But what was really important, I think, was, and especially this first group of military defense lawyers, when the Supreme Court decided to hear the Rasool case. They made that decision in November of 2003. And then these JAGs, the defense lawyers, basically signed an amicus brief. And that was really what Schmidt said was like really something that indicated to the public that there was dissent in the ranks, you know. And so I think that that was part of the story. It's, you know, and kind of revealing that, I mean, and I'll tell you, like, just as, you know, on a personal level, prior to my research, you know, I'm a, you know, good lefty, and the conscription ended when I was, you know, in the U.S. military, ended when I was a child, and so you know, I didn't really know many people who were, you know, active service people, but then getting to meet these you know, military lawyers who were like fighting back against the administration on you know, principles, was something that definitely reshaped some of my perceptions, at least about military lawyers, like coming to realize that my, you know, sort of one size fits all view of the US military wasn't really accurate. And I remember, you know, at being at a merit meeting, a Middle East report meeting, sometime around that when I was starting my research, and, you know, some of the editors were like, who would have imagined, you know, US soldiers are championing human rights? It was very, I mean, and I think that that had a broader ramifications for, you know, just kind of creating, you know, multiple meanings about what was going on.
You make the argument again that lawyers and the courts were critical to the campaign against torture, in large part because, as we briefly discussed, politicians and public opinion were, for the most part, either supportive of or uninterested in the issue, or presumed to be either supportive or uninterested. You conclude that ultimately this was a battle that could only have been waged within the court system. So was this primarily on account of the broader political environment of support and apathy, or was it also a reflection of the often arcane legal nature of the issues in contention, in addition to those of principle?
Right. I think both of those things are true. So up until the Rasool decision in June of 2004, which opens Guantanamo to lawyers, although lawyers were subject to protective orders, meaning they couldn't talk about it. Really, for years, the Bush administration was able to control the public narrative because of the secrecy. And even the lawyers who were then able to access detainees, whether as habeas counsel or as their defense lawyers, were barred from revealing anything that they learned about how their clients had been treated. So the administration really had a monopoly on the public narrative. They could continue to say, we treat people humanely, you know, everybody at Guantanamo is a guilty terrorist, and our interrogation tactics are working fabulously to produce excellent intelligence. And so it was really, in a sense, it was the way in which the administration reinterpreted the law, coupled with this secrecy that meant, first of all, the public didn't really have much basis other than, you know, human rights reporting and investigative journalist exposés to even appreciate that there was a totally different reality than that which the propaganda of the administration was extolling. But it really was because of the legalization of torture in very complex ways, you know, like, when do military laws apply? Where does the Constitution apply? What kind of rights do non-state actors have? And, you know, what power does the president have? All of those things raise very complicated legal issues. And so I think it was that confluence that the public for a long time was willing to accept what the administration was saying, because they didn't really have access to contrary information. And people who did have access to contrary information were barred by, you know, protective orders from revealing it. And so it meant that everything had to be fought out in the courts. And the only people who can fight in courts are lawyers. And so that's really sort of part of this kind of narrative, the trajectory.
And speaking of more public revelations, journalists were initially, and for the most part, wholly on board with US policy in the years after 9/11. Their cheerleading for the Iraq War, for example, is legendary. Yet several eventually came to play an important role. You mentioned Barton Gellman and Dana Priest in reporting on torture, whether in Abu Ghraib or Guantanamo or elsewhere where it was revealed. So what was the role of journalists in the larger story you described? We tend to focus on their revelations, but did they also, for example, play an important role in shaping public opinion to accept this torture program?
Well, I think I would say, we sort of, to like break apart the kind of general category of journalists. I mean, certainly, sort of the White House press corps and, the people who were really getting their talking points from inside the Beltway did, sort of, amplify the Bush administration's, talking points, which were propaganda and lies. But early on, not only Dana Priest and Barton Gellman, but, Jane Mayer, Jeremy Scahill, a number of investigative journalists really were, along with human rights organizations, Human Rights Watch and Amnesty International investigators, were really producing through their own investigations a kind of counter narrative. And so that was something that, I think that we can give some journalists incredible credit. And particularly if we want to take the long view and, Guantanamo is still open, Carol Rosenberg has been like an unprecedented source of truth and information. I mean, she was at Guantanamo, from the time the first prisoners arrived in January 2002, and she continues to go, almost the only journalist who continues to go to Guantanamo constantly. She covers every single military commission hearing. And so I would say, especially in the last 6-7 years, almost everything we know about what's happening at Guantanamo, we know because Carol Rosenberg reported it.
Mm. And would you say that the pictorial evidence that emerged from Abu Ghraib was also an important turning point in alerting public opinion to the very, let's say, real impact of this policy?
Yeah. So the Abu Ghraib photos, these shocking photos of U.S. soldiers torturing mostly naked Iraqi prisoners in the Abu Ghraib prison, those photos were taken in 2003, but they were published on CBS 60 Minutes 2 on April 28, 2004. And those photos really were perhaps a major pivot in two ways. Like, one was that it completely demolished the administration's claims that there was, torture wasn't happening and all detainees were being treated humanely. And that scandal then pressed Congress to start, in May of 2004, calling hearings with military and civilian officials to try and find out what's actually happening in our secret detention facilities. And that pressure, induced the Bush administration to start releasing a few documents, which instantly were called, and they were like legal memos and Pentagon policy directives, which were instantly branded the torture memos, because what they revealed was not only that Abu Ghraib was not like, animals on the night shift. It was, what happened at Abu Ghraib was the part of a much larger policy of torture authorized from the top and varnished with legal opinions. And so what makes all that so crucial to this larger story I tell was that that's the moment when, the small group of lawyers around Michael Ratner, Margulis, Stafford Smith, and, the Center for Constitutional Rights, they'd been kind of fighting a lonely battle in the lower courts. And after those revelations, especially the torture memos, lawyers around the country were absolutely exercised about what the Bush administration had done. And so in June of 2004, when the Supreme Court issues its ruling in Rasool v. Bush, basically saying Guantanamo detainees have habeas rights, lawyers, first by the dozens and then by the hundreds, volunteered to represent Guantanamo detainees as habeas counsel. And so that was the origin story of what they call the Guantanamo Bay Bar Association, or the Gitmo Bar. And at its peak, it had over 600 lawyers and over 100 law firms. Conservative, Republican lawyers, corporate lawyers, human rights lawyers, family practice lawyers. It was like lawyers, from every walk of the profession kind of took an opportunity to use their legal skills to defend the rule of law. And that was really what was happening. And then, they start going to Guantanamo in August of 2004, slowly meeting clients. As I said, they were subject to a protective order. But then for a couple of years, you have these lawyers meeting people. It's the first time, non, guards and soldiers and interrogators are meeting people, and they're learning what's really happening at Guantanamo and what really happened when these people were at Bagram before they got to Guantanamo, the kind of torture, abuse, inhumane treatment, but they're barred from saying anything. And so that also creates a certain kind of pressure. Like lawyers were the unwilling keepers of the president's secrets. And so then you get, sort of investigative journalists opening up things. And so, but it really is, it's a very like multi-party, multifaceted efforts to kind of pull things, from secrecy into the light and expose and challenge the government's interrogation and detention policies.
Well, I think as you've just described, your book, The War in Court, is very much a book about secrecy and illegality on the one hand, and the effort to uncover the secrecy and confront the illegality on the other. So for you as a researcher, what was the experience of researching and writing this book? Did you, for example, encounter systematic obstacles or obstruction to your work? Were people willing to speak with you, or were they trying to get you out of the way? How did that work, and how did the process develop?
What's a good question. I mean, whenever a scholar takes on a new research project, if it's really new, you have so much learning to do. So first of all, I would say, just in terms of your question about pushback, I didn't get any pushback because I was basically focusing on the lawyers who were challenging the administration. So I wasn't trying to interview the war council lawyers. I mean, their information about them
was not one of your
exactly. Although I did start, doing my first, sort of taking my critique on the road was a talk I was giving at a bunch of universities called "What's the Matter with You?" Really starting focus. But because I was focusing on lawyers who were doing this kind of work, they were happy to talk to me to the extent that they could. I mean, obviously, my early conversations with lawyers, they would have to balance what they could say and keep, classified. Like they couldn't tell me how their individual clients were treated. But I would just say, coming back to the point about how one does research. So I've always been fascinated with lawyers. I mean, my first book on the Israeli military court system in the West Bank and Gaza was very much, I interviewed defense lawyers, prosecutors, Israeli military judges, et cetera, and really came to understand, sort of the role of lawyers in the course of conflict. And I had learned a lot about like the Geneva Conventions and human rights law, et cetera, through that research. But when I started working on this project, I'm so grateful to many of the lawyers who I interviewed, because I didn't know anything about, the Uniform Code of Military Justice, or, I didn't know much beyond the real rudimentary basics of like constitutional law or executive powers. And so part of the research process for anybody, but I'd say I felt this myself, was like going from a level of expertise that was defined by what I learned from watching Law and Order to like obtaining, this much more sophisticated understanding of the law. And that's one thing I try to do in my book, because it's written as a trade book. It's not an academic. It's not written just for academics, although I think academics may find it interesting, but I really wanted to share what I learned about these complex legal issues with
and
readers.
How you learned it.
Yeah, and how I learned it and make it readable, etc. So those were some of the things. But I'll tell you one thing, just as an aside, like one of the things that's challenging about interviewing some lawyers, like the nature of my research, since I'm a sociologist, part of what I wanted to do was understand who these individual lawyers were, like what their background was, like how they, what their political views were. And some lawyers basically are like, all they want to talk about is their work. They don't want to, like, they sort of couldn't pivot into like me, the human being who has opinions, So there was a little bit of like, that would be like perhaps the only frustration I had was, getting lawyers to be introspective about themselves a bit. So, but I would find that information through other means.
Finally, Lisa, in the conclusion of your book, The War in Court, you write, and again, I'm quoting, "The torture program is over, but its specter haunts U.S. politics because there has been no meaningful acknowledgement that government policy constituted gross crimes. let alone redress for torture and cruel treatment intentionally perpetrated against thousands of people taken into US custody during the War on Terror, end quote. This leads me to actually two final questions. First, can you elaborate on this statement? And secondly, if you agree that racism played a prominent part in the US torture program, and you've, in one of your previous answers, you've indicated that you do believe this to be the case, does this also help explain its growing adoption by US domestic security forces in, for example, policing African-American communities and within the US prison system?
Wait, that's like about 7 questions. So I would say, first of all, nothing, at least, I mean, interrogation tactics, there were some places in the domestic United States where torture was used. For example, Chicago has, as we now know, a long history of police torture of some of the kinds of techniques that were used at Guantanamo. But the cruel and inhumane and degrading treatment that detainees were subject to at Guantanamo and other sites are not unlike, the harsh conditions in some US prisons. So in some ways, it wasn't like the torture program for the War on Terror tainted a clean criminal justice system by any stretch of the imagination. But one thing, and this is something where, especially early on in the War on Terror, where activists in the United States were very, focused on prison abolition and police racism, et cetera, were kind of frustrated that Guantanamo for a time, from in the first, say, decade of
sucked all the oxygen out of the room.
Exactly. But the one thing I would point out is that the ability to fight how the US was treating people at Guantanamo raises different legal issues than domestic things because of the fact that this is an international situation. So international law applies and can be applied. So that's one thing. A second thing I would say is that it was, there had not really been like a pro-torture constituency prior to the development of the torture program. But once the Abu Ghraib photos come out, all the Islamophobes and the right-wingers latch onto this and actually see it as, it was a sort of a way of becoming pro-torture, was one more way for racists to manifest their hostility to Arabs, Muslims, others, the range of others. And because it was a Republican administration that had instituted the torture program, to then view any critics of the torture program as anti-American, as torture supporters, et cetera. And so that we see that happening, after the publication of Abu Ghraib. But what really, shows, the colors of this large sector of the American public was in 2009, shortly after Barack Obama had taken office, and, his legacy I go into in quite extensive detail, which is more of a Pyrrhic victory. But at least on his second day in office, he basically, he had run on a campaign denouncing the torture program and promising to restore the rule of law. And on the second day in office, he signed 3 executive orders, one of which basically ended the CIA's torture program. And it was after that that support for US torture tips over 50% in the United States. And basically, and so, and over the years since then, the Republican Party has become the pro-torture party. You can see this in the positions that various Republican politicians, including former President Donald Trump and other people. And there's just this kind of nostalgia for the age of so-called enhanced interrogation techniques that Republicans, mourn their passing and might like to see them brought back. And so that's part of what I mean about the specter haunting US, the United States. But it's also, the one last point, and this is where, Democrats don't get, Democratic politicians don't get a pass on this, was that the kind of expansion of executive power that was instituted, by Cheney in order to, insulate the president from certain kinds of oversight. Although Obama had criticized that, and many Democrats had criticized that during the Bush administration, when Obama comes to office, we have not rolled back the kind of executive excess that was instituted by the Bush administration. And one can see that with, the way in which the Obama administration prosecuted drone warfare on the same kind of legal reasoning. So just as the Bush administration had said, anyone we take into custody is a terrorist and therefore they have no rights, the Obama administration said torture is bad, but anybody we
drones are good.
Anybody we extrajudicially executed is guilty, therefore their death was justified and keeps America safe. So we have not in any way, as the United States is not in any way as a nation, come to terms with this. And those, institutional features they bode ill for the permanent, negation of torture in the future.
And although, as you point out, the torture program is over, Guantanamo is still open for business. Any final thoughts on that?
Right. Well, even though the Biden administration, ended the war in Afghanistan, which was like the first and last hot war theater of the war on terror, as long as Guantanamo is open, the war on terror is not over. And so currently there are 35 people left at Guantanamo. 9 of them are on trial. 1 of them is waiting sentencing. 1 served his sentence, but is waiting to be relocated. 20 were cleared for release, but have yet to be relocated. And 3 are forever prisoners who will never be charged or tried. And so this really, the inability of the US government to close Guantanamo, despite that it is like, except for the most delusional partisans, it is a complete and abject failure, even by the very reasons it was established in the first place. It's a festering boil on the butt of America that cannot be excised because of domestic politics.
Lisa Hajjar's compelling and fascinating The War in Court was published by California University Press last month. Lisa, I'd like to thank you for sharing your expertise and insights on connections. Thank you very much.
Thank you, Mouin. It's been an honor.